Okay, so I think we must resume our work. This is the official first lecture on private international law of this session. So I think that you were expecting it and you were waiting for it. So I will come now to the podium Professor Linda Silberman. Professor Linda Silberman is the Clarence D. Ashley Professor of Law Emerita at New York University School of Law. She's also the co-director of NYU's Intesa San Paola Center for Transnational Litigation, Arbitration and Commercial Law. Her scholarship covers a wide variety of topics in civil procedure, conflicts of laws, transnational litigation, and international arbitration. As I said, in summer 2021, Professor Silberman delivered the heroic Hague Academy General Course on Private International Law remotely, but I've been told that it will be published in the Recueil very soon. So it will be delivered, of course, in English. I welcome Professor Silberman.
Thank you very much, Professor Tuvenen, for those remarks and your earlier ones. I said I would be very embarrassed if my French were better and I could have heard all of it, so I only had to hear pieces of it and I'm embarrassed enough. So thank you very much. As you can imagine, it is an absolute thrill to be here. I did deliver the short course so many years ago, but the general course done in 2021 was remote and asynchronous and difficult for me, and particularly difficult because there were none of you really there. And so I am very grateful to the Academy, and I am thrilled to be here. It is from the bottom of my heart I say thank you all very much. Now, my topic for this inaugural lecture, Cooperation and Communication in Private International Law, offers a brief overview of global efforts in private international law over the last several decades. And I touch on subjects that you will hear much more about in your weeks in this overall course. And because it is an inaugural lecture, I really just touch on them. But the methods of cooperation in private international law among nation states have changed over the years as cross-border activity has expanded into many different substantive areas. As a result, cooperation takes a variety of different forms and addresses not only the classic areas of private international law, like choice of law, jurisdiction, and recognition of judgments, but also cooperation in various types of cross-border litigation, including family disputes, with an added dimension of communication. Now, of course, cooperation is not without limits, as Professor Matthias Weller details in his 2019 Hague Academy Lectures on Mutual Trust, in identifying how the invocation of public policy in various treaties and other cooperative arrangements strains the principle of mutual trust. Nonetheless, an increased role for cooperative efforts, even when restrained, is characteristic of private international law and has come to prevail over unilateral approaches to private international law. And that cooperation operates at the multilateral level as well as the regional level and can take the form of hard law instruments such as treaties and regulations, or soft law instruments such as model laws, principles, and guides. And so this lecture is a brief survey, or perhaps smorgasbord is a better term, of various models of cooperation over the last few decades. I'm going to start with the unification of substantive law. One of the most obvious ways to achieve global cooperation in a specific area is unification of a particular substantive law in an international treaty, or via the international implementation of identically worded binding legal rules that are meant to be interpreted and applied in the same manner across different jurisdictions. One of the most successful such uniform law endeavors, of course, is the one that most of you know, and that's the Convention on Contracts for the International Sale of Goods, the CISG. That convention currently has 97 signatories and consistently serves as the basis for resolving disputes in cross-border sales. There are others, the International Fine Leasing and International Factoring conventions that touch on key substantive issues. But it's worth noting that even the CISG effort at uniformity is limited, since the convention is not exhaustive and leaves open many issues. And in the absence of a supranational authority, uniform application of legal rules cannot be guaranteed. Still, certain efforts at achieving greater consistency in judicial interpretation have proved fruitful. For instance, the CISG website maintained by Pace University Institute of International Commercial Law compiles court decisions that address provisions and endeavors to provide translation where possible, enabling courts to read more readily rulings on given provisions from myriad jurisdictions. In addition, of course, there are uniform law cooperation at the regional level, such as OHADA, which created a unified set of substantive commercial laws for West and Central Africa, with court decisions subject to review by a supranational tribunal. We move then to thinking about cooperation a little differently, and that is through uniform choice of law rules. Those also operate at the global and sometimes the regional level, and sometimes involve a treaty that adopt choice of law rules to be applied in each country that's party to the convention. Now, the leader in this field, of course, the Hague Conference on Private International Law, and they have done this in a variety of substantive areas with the negotiation and completion of several treaties to address the applicable law in specific types of cases. We can mention the 1971 Convention on the Law Applicable to Traffic Accidents, the 1972 Convention on the Law Applicable to Products Liability, and the 1978 Convention on the Law Applicable to Matrimonial Property Regimes, the 1985 Convention on the Law Applicable to Trusts on their recognition. And that's a host of substantive areas, and they reflect a significant achievement in harmonizing conflict of law rules across jurisdictions and minimizing forum shopping for applicable law in cross-border matters. Again, in the interest of time, just short references. The 1971 Traffic Accidents Convention provides that the applicable law is generally that of the state where the accident occurred, promoting predictability in cross-border motor vehicle cases. The 1973 Products Liability Convention clarifies applicable law in complex product-related disputes by establishing a hierarchy of connecting factors, such as the habitual residence of the injured party or the location of the product's marketing, thus facilitating clearer outcomes for all jurisdictions. The 1978 Matrimonial Property Regime Conventions created a unified set of rules governing property rights between spouses, often a point of tension in international marriages by allowing parties to choose the applicable law and specifying situations that qualify a state's law as a valid choice. On choice of law, it is probably cooperation at the regional level that's most effective, and the model here, of course, is the EU. One of the most well-known examples is the earlier 1980 convention that supplanted national private international law with uniform rules and dictated the applicable law in civil and commercial matters. And then, of course, it's updated with the Rome I regulation. And, of course, we have a supranational institution, the European Court of Justice, to provide authoritative interpretation of these rules. The regulation has, as the convention did, a universal scope, meaning that any law specified in the convention or regulation is to be applied regardless of whether it's a law of a member state. And in addition to embracing the principle of party autonomy, the Rome I regulation provides a number of formal choice of law rules for specific types of contracts, as well as a residual rule for other kinds of contracts. Flexibility remains in the form of the usual exceptions when the contract is manifestly more closely connected with another country, as well as the important roles for overriding mandatory rules and public policy. Following on, in 2007 was the EU's adoption of the Rome II regulation, which established conflict of law rules for non-contractual obligations in civil and commercial matters. Like Rome I, any law specified will be applied regardless of whether it's the law of a member state. In addition to the general rule prescribing application of the law where the damage occurs, but subject to an exception for manifestly more close connection with another country, Rome II has specific choice of law rules for certain types of torts, such as product liability, unfair competition, and cross-border environmental damage. Again, with respect to any of these rules, there's the exception for the application of overriding mandatory law of the forum, as well as public policy. The Rome III regulation, entitled Implementing Enhanced Cooperation in the Area of the Law Applicable to Divorce and Legal Separation, deals with the law applicable to the grounds for divorce and legal separation. The parties can choose the applicable law as long as it satisfies certain close connections, and in the absence of choice, there's a cascade of connecting factors to determine the applicable law. In addition to the usual general public policy exception, there's an interesting provision that states that the regulation does not oblige courts of a member state whose law does not provide for divorce or does not deem the marriage in question valid to pronounce a divorce. So the limits, really, in some ways, on cooperation. At the regional level, there have been efforts, but really, I think, a less successful path. Within the Organization of American States, OAS, the 1994 Inter-American Convention on the Law Applicable to International Contracts, the Mexico City Convention, prescribes choice of law rules for international contracts between parties whose habitual residents are in different states. But interestingly, only 2 states joined that convention. But rather than promoting additional ratifications of the convention or embarking on efforts to amend it, the OAS produced a formal guide to support efforts by member states to modernize their domestic law on international commercial contracts with respect to party autonomy for the choice of the applicable law, and in accordance with international standards, referencing the Hague Conference soft law instrument, Principles on Choice of Law in International Commercial Contracts. I move now to the other traditional area of cooperation, and that's the recognition of judgments. At the multilateral level, the Hague Conference in 1971 tried but was unsuccessful. It required bilateral agreements, none were concluded, so the convention was never operative. So in looking for success, one looks to regional cooperation. So in 1979, the OAS adopted the Inter-American Convention on Extraterritorial Validity of Foreign Judgment in Arbitral Awards, that is the Montevideo Convention, in effect in 10 countries. In the Gulf region, most members of the League of Arab States are party to the 1983 Riyadh Arab Agreement on Judicial Cooperation, which, among other issues, provides for the recognition and enforcement of foreign judgments where the foreign court was competent under the jurisdictional rules of the requested state, subject, of course, to certain defenses. And although there is no regional arrangement for Asian countries, China has over 30 bilateral treaties on recognition and enforcement of judgments and considers it an important pillar of the One Belt, One Road initiative. The most successful regional convention, again, is the 1968 Brussels Convention, later updated in the EU regulation in 2001, and now in the 2012 Brussels recast. Both the convention and the regulation are in the form of a double convention, whereby member states agree to specific bases of judicial jurisdiction in the member states for particular types of cases, where only those bases of jurisdiction can be exercised, and member states agree to recognize and enforce the judgments of member states, subject to a limited set of defenses and without exequatur. Again, the European Court of Justice provides an authoritative voice with respect to interpretation of the regulation and helps to achieve uniform understanding of its various provisions. At the multilateral level, once again, the Hague Conference tried again in 1992. And it was thought maybe that the European framework might work. It was thought it was too restrictive. So the Hague tried something different. They tried a mixed convention that would provide for required and prohibited bases, but also a category of permitted jurisdiction. Unfortunately, differences about what belonged in the respective categories led to a stalemate. And so, not to give up, the negotiators turned to consideration of a more modest convention that resulted successfully in the 2005 Hague Convention on Choice of Court Agreements. That framework provides that courts of contracting states will assert jurisdiction to decide a dispute where parties have entered into a choice of court agreement, second, suspend or dismiss a proceeding brought in contravention of an agreement, and recognize and enforce judgments by a court designated in exclusive choice of court agreements. The convention also provides that the law, and here we refer to the whole law of the chosen court, that will determine the validity of the forum selection clause and sets forth a limited number of defenses regarding enforcement of both the choice of forum agreement and or the resulting judgment. But building on the successful negotiation of the choice of court convention, the Hague Conference continued its efforts to produce a multilateral convention addressing the recognition and enforcement of judgments. And unlike the earlier negotiations that reached the stalemate, the 2019 judgment is successful. It offered what is referred to as a single convention, meaning that the treaty deals with judgment recognition and enforcement alone and not direct assertions of jurisdiction. So the convention takes the issue of jurisdiction only as a matter of eligibility and accordingly identifies those jurisdictional grounds that will be accepted in support of the judgment at the recognition state, i.e., a matter of indirect jurisdiction. The convention is limited to civil and commercial matters, and it has broad exclusions in terms of subject matter, so defamation, privacy, arbitration, most competition and intellectual property judgments are outside, but it does require recognition and enforcement of an eligible judgment, one that fits, subject to a set of defenses that permit but do not mandate non-recognition. There's one exception that requires non-recognition with respect to a judgment determining an in rem right in movable property if the property is not situated in the judgment state. Otherwise, the convention operates as a floor and not a ceiling, and it permits broader recognition and enforcement of judgments covered by the convention under national law. So greater cooperation under national law is possible. The convention is enforced in member states of the EU, Ukraine, Uruguay, and as of this month, the UK, and other countries expected to join shortly. It would be a mistake, of course, not to mention the convention that best illustrates the model of multilateral cooperation among different countries, even without supranational oversight, and that's the New York Convention of 1958. Almost every commercial state has become a party, with 172 state parties overall, and the convention has been heralded as the cornerstone of the international arbitration system. The main objective of the convention was to make arbitral awards rendered in a foreign state enforceable in any country party to the convention. And notwithstanding the formal title, the convention also covers agreements to arbitrate. It requires recognition of such agreements and obligates courts of a contracting state to refer the parties to arbitration unless it finds the agreement is null and void, inoperative, or incapable of being performed. And as for recognition and enforcement of awards, There are limited defenses. Some relate to defects in the arbitral process or procuring of the awards, and others, namely non-arbitrability and public policy, are based on the laws of the country where recognition and enforcement is sought. The Convention has played a central role in facilitating international trade and investment by ensuring that arbitral awards are reliably enforced across borders and thus reducing risk in cross-border transactions. And in the context of international investment law, the Convention has also provides the enforcement backbone for many investor-state arbitral awards. 60 years later, we get again, cooperation, this time with mediation. So the Singapore Convention, drafted in 2018 by UNCITRAL, was an attempt to extend the success of the New York Convention to mediated agreements. The growth and value of mediation as a method for settling international commercial disputes prompted this effort. And unlike the New York Convention, the Singapore Convention does not provide for the enforcement of agreements to mediate. But once a mediation settlement agreement has been concluded, the Convention provides for both the enforcement of that agreement and the right of a disputing party to invoke such a settlement in the context of litigation. The grounds for refusal to enforce a mediated settlement agreement are similar to those in the New York Convention, but they, of course, are adapted to suit the special context of mediation. So, in one sense, the Singapore Convention represents a double dose of cooperation. That is, the voluntary cooperation of the parties to an international dispute through an amicable settlement, through mediation, and an international framework to ensure recognition and enforcement of those agreements. So I'm now going to change a little bit to talk a little bit about cross-border cooperation and communication in litigation. Because cross-border litigation turns out to be an area where we need cooperation on procedural matters, but choice of law and jurisdictional solutions don't fit. So one looked to other methods for things like service of process and obtaining evidence. And once again, we start at the multilateral level with cooperation with the conventions of the Hague Conference, the Service of Process Convention, which has as its core a central authority mechanism. Under that convention, contracting states undertake the obligation to serve documents at the request of another contracting state, subject to conditions laid down in the convention. Each state designates a central authority responsible for handling requests for service in civil or commercial litigation, including furnishing proof of service to the requesting state. Requests can come from a country's central authority, but also from courts or private parties. The central authority either serves the document itself or arranges for service by one of the means laid down in the convention. It also authorizes states to agree to other service by additional means. The evidence convention is also interesting because courts in one country generally have discretion whether to comply with requests for evidence emanating from another country's courts or litigants. So in order to ensure cooperation, one needs some kind of international agreement. And that objective was achieved to some degree with the 1970 Hague Evidence Convention, which covers requests for evidence, although its reach is limited to use in judicial proceedings and only in civil and commercial matters. Under the convention, contracting states are legally obligated to receive and enforce requests for production of evidence submitted by other contracting states. Again, like the Service Convention, it adopts the mechanism of a central authority to receive a letter of request from a judicial authority of a contracting state. The central authority can then direct the request to the appropriate court within the country. Critical to the convention's success is the obligation imposed to offer measures of compulsion in executing orders pursuant to those letters of request. The convention provides for additional methods of evidence through consular agents and commissioners, but even there are a variety of restrictions, and here you have no coercive measures to ensure compliance. And unlike the Service Convention, the Evidence Convention is not exclusive. So courts with jurisdiction over a person subject to an order can rely on their own national laws if they want to obtain evidence. However, when evidence is sought from persons over whom a court lacks personal jurisdiction, often non-parties, the convention will be the only available avenue. And differing views in countries about obtaining documents prior to trial, that is what we know as pretrial discovery in common law countries, led the convention to include an article that allows contracting states to declare that they will not execute letters of request for that purpose. And so many countries have taken some form of that Article 23 declaration. So cooperation in this area still remains limited. Although I've talked most about the multilateral convention, it's worth noting that there are similar conventions at the regional level. The OAS conventions on letters rogatory and taking of evidence, and the 2020 recasts of the EU service regulation and the EU regulation on the taking of evidence abroad. The 2020 recast on the taking of evidence includes new provisions that accept direct taking of evidence, that is, foreign judicial authorities being active on their territory under certain conditions. I'm now going to move to talk about a transformation of cooperation in the area of family law. The jurisdiction and choice of law models used in the other areas of private international law were really, I think, too theoretical and abstract to address many cross-border family issues. And any kind of substantive harmonization was even less likely, given the various different cultural and legal traditions around these issues. And those limitations became obvious in the 1960s and 70s as family law matters became the subject of numerous Hague Conference conventions on marriage, divorce, protection of children, with none being widely adopted. So a different approach was inspired by the two modern civil procedure conventions on service and evidence that I just discussed, both of which instituted this mechanism of a central authority to undertake various tasks along with methods of communication among central authorities. And a similar model of cooperation was then envisioned for the 1980 Hague Convention on the Civil Aspects of International Child Abduction, which instituted a central authority tied to the specific purpose of that convention. Cooperation through central authorities along with direct communication, direct judicial communication, became a fixture for other Hague conventions, was broadened in the 1996 Child Protection Convention, and we see all of that as well at the regional level on the Brussels II bis and ter regulations on parental responsibility. So we see a lot of different kinds of cooperation and communication in this area. I want to say just a brief word about the Abduction Convention, which does not provide rules for jurisdiction for custody disputes or require enforcement of a judgment. Instead, a party with rights of custody requests the return of a child who has been wrongfully removed from its habitual residence. This obligation is imposed on both judicial and administrative authorities of the contracting states, but in practice, it's the judicial authorities who make the return order upon the filing of a return application. The return remedy is the critical element of cooperation under the convention, but it includes other important features. So a primary goal of the Abduction Convention is to secure return of the child without having formal proceedings. And so to that end, the convention imposes an obligation on each country to create a central authority responsible for coordinating the numerous tasks necessary for a child's return. And those obligations are two-way responsibilities. outgoing cases in which a child is taken from one country to another, and incoming cases in which a child is currently in a country as the result of the alleged wrongful removal or retention. In the outgoing cases, the central authority in the child's habitual residence may help process a request to have the child returned. It can provide information about options and resources available in the foreign state, and it can contact the relevant central authority in the state to which the child has been taken for help in securing and locating the child. In incoming cases, the central authority may assist in locating a child, help to facilitate access to legal assistance, and in some countries, institute proceedings to secure return of the child. In addition to this cooperation and communication among central authorities, there is also direct cooperation among the courts of the requested and requesting states. Although in 1980, the drafters of the convention did not have the foresight to include provisions on direct judicial communication in the convention itself, ensuing practice under the convention revealed the need for such a tool. And so the Permanent Bureau at the Hague Conference developed the initiative of the International Hague Network Judges, and the conference developed and published a guide regarding the development of these Hague Network Judges, along with general principles for direct judicial communication. Although communication often takes place between network judges and central authorities, and or between the network judges themselves, the guide identifies a number of issues where direct communication between judges in a specific abduction case may be particularly helpful, such as where protective measures will be available for the child and parent in the country to which the child will be returned, and or whether a foreign court will accept and enforce orders made in the state of refuge. The 1996 Hague Child Protection Convention, its full name, the Convention on Jurisdiction, Applicable Law, Recognition, Enforcement, and Cooperation in respect of parental responsibility and measures for the protection of child, gives you a sense of the wide range of cross-border issues affecting children. Now, it can be viewed largely as a jurisdictional and recognition of judgments convention for custody and access orders, but it includes other provisions addressed to cooperation for the broad range of its coverage, such as guardianship, placement of a child in foster care, supervision by a public authority. And like the Abduction Convention, it provides for a central authority to facilitate cooperation, communication, and exchange of information between contracting states. But the cooperation, of course, given its broad scope, is much more extensive, and the responsibilities under this convention are likely to fall to a variety of different local authorities and institutions, including courts. One of the, I'm not going to go through all of it in the interest of time, but one of the unique ideas adopted in the 1996 convention was to permit a transfer of jurisdiction by the state of habitual resident to specified contracting states that might be better placed to assess the best interests of a child. And concomitantly, authorities in these identified states can make a request that they be permitted to take jurisdiction. Now, if you think about it, in order to effectuate such provisions, the convention in Articles 8 and 9 speak generally to provide that authorities may proceed to an exchange of views and may authorize communication between authorities directly or with the assistance of central authority, and one can look to contracting states to see how they have passed legislation to implement all of that. At the regional level, of course, we have the more recent Brussels II-TER, and they have, if you will, even more robust provisions of cooperation as is probably possible at the regional level. The scope of Brussels II-TER is broad, addressing not only issues of jurisdiction and recognition in matrimonial and parental responsibility matters, but also including detailed provisions about child abductions and transfers of jurisdiction within the EU. And significantly, the regulation has expanded and specified the obligations of central authorities in matters of parental responsibility, such as that of providing information about different services, both in general matters and in specific cases, including for purposes of promoting amicable resolutions. And in addition to cooperation among central authorities, the regulation in Article 86 expressly provides that courts, I emphasize courts, may cooperate and communicate directly with or request information directly from each other, and those direct communications are expressly noted for transfers of jurisdiction between member states and for child abduction matters. I probably at this point should mention the European Judicial Network in civil and commercial matters established in 2001 and noted in the practical guide for the Brussels II-Ter regulation. It has a much broader compass than just Brussels II-Ter. The network, made up of national authorities and courts, was established to support, improve, and accelerate judicial cooperation more generally between member states in civil and commercial matters. There are contact points set up in each member state to provide services to the courts and judicial administrations. In addition, the network facilitates official judicial liaison, enables judges in different EU jurisdictions to discuss and resolve questions relating to EU instruments and policies, as well, again, as encouraging direct judicial communication and coordination under the new Brussels II-Ter regulation. And so in the family area, we have seen really amazing efforts at cooperation. The other area I want to turn to, I promised across the board, is transnational insolvency. And that's a specific area where cooperation and communication have been mandated. The compromise between universalism and territorialism for transnational insolvency in both the UNCITRAL model law and the EU insolvency regulation that incorporate parallel proceedings for insolvency cases. If you want to do that, you certainly have a need for cooperation and communication among these courts. And transnational solvency proceedings, for those of you less familiar, are often conducted with a main proceeding where the debtor has its center of main interests, and secondary proceedings, both non-main proceedings where the debtor has an establishment, and ancillary proceedings where a debtor has assets or where the creditor seeks relief. Again, in the interest of time, I am going to skip over the EU insolvency recast and turn instead to the UNCITRAL model law, which has, of course, the broader scope. It's a broader scope in terms of application, but looser approach to global cooperation in insolvency. And that's the UNCITRAL soft law instrument, the model law on cross-border insolvency, which is aimed at increasing legal certainty, fairness, efficient administration in transnational insolvency cases. Its adoption in many jurisdictions, including in the United States, is Chapter 15 of the Bankruptcy Code, as well as Great Britain, Canada, South Korea, Japan, Chile, the Philippines, South Africa, and the Congo, to name just a few. So this marks a global shift towards structured cooperation in insolvency matters. The model law adopts the principle of modified universalism that centralizes the main insolvency proceeding in the debtor's center of main interest and provides for other courts where assets are located to recognize that proceeding and to transfer any local assets. It does not deal directly with jurisdiction or applicable law, but adopts procedures to achieve greater efficiencies in administering international insolvency cases. For example, it enables a foreign representative to apply directly to local courts without additional authorization in order to seek the opening of local insolvency proceedings involving the debtor. It promotes participatory rights for foreign creditors. Recognition of a foreign main proceeding can trigger certain automatic consequences, and recognition can be refused if it would be manifestly contrary to the public policy of the enacting state. Perhaps the most successful features of the model law is that of communication and cooperation. Article 25 explicitly mandates that the court shall cooperate to the maximum extent possible with foreign courts or foreign representatives. Article 27 further specifies that communication of information can occur by any means considered appropriate by the court, allowing for flexible coordination without traditional time-consuming methods such as letters rogatory. The model law provides a framework for coordinating concurrent proceedings concerning the same debtor in multiple countries. And in order to make appropriate assessments of how they should proceed, courts themselves have adopted guidelines for communication and cooperation set forth by the Judicial Insolvency Network in service of the general provision in the model law. And those guidelines have often made their way into formal court rules. I had some examples, but again, in the interest of time and your patience, I'm going to skip that and go on to an ongoing project on parallel proceedings at the Hague Conference. As you might guess, this positive experience with court-to-court communication in cross-border insolvency has found its way into an ongoing project of the Hague Conference. And it's about parallel proceedings more broadly. The proposed convention is one that is looking to provide criteria and mechanisms for dealing with the same or related actions in courts of different countries. The operational objective reflected in the latest 2025 draft provisions and report of the working group is the elimination of parallel proceedings through selection of a single forum to proceed to judgment, except where the interests of justice and efficiency are actually served by parallel proceedings. But that task requires a methodology to reconcile civil law traditions of, as you know, first to file lease pendens with common law traditions of forum nonconvenience. Whether to require certain jurisdictional connections to qualify as an appropriate forum and what factors should be considered in determining the more appropriate court are still a matter of debate and discussion, and that is ongoing. Another critical issue is which court or courts are to make the determination about the appropriate court. But however that issue is resolved, cooperation and communication will be critical. The latest working draft includes a general provision that courts, quote, undertake to cooperate with each other and they're encouraged to exchange information. There's a more specific provision on the mechanisms for communication that include, where possible, direct judicial communications between courts and indirect judicial communication through a competent authority, along with details about the manner of cooperation. And also included there is an option for states to authorize joint hearings. I guess that's sort of influence from the transnational insolvency. And although coordinated proceedings seem to have worked there, and now I say this personally, I'm not persuaded that that experience is easily transferable to the much broader international civil and commercial context with very, very different types of cases. So, a final illustration of cooperation I want to mention is perhaps less familiar to you as it was to me initially. And technically, I think it's not private international law, but the model, I think, is extraordinarily interesting, and that is the OECD, the Organization for Economic Cooperation and Development Anti-Bribery Convention, which offers a unique model of international cooperation with respect to the enforcement of foreign anti-bribery laws in the form of peer review and pressure. The adoption of the convention in 1997 followed years of lobbying and pressure from the United States, ironically, I have to say now, which had criminalized foreign bribery and related offenses many years earlier under the Foreign Corrupt Practices Act of 1977. Apologies. The design of the convention reflects a soft law approach to enforcement cooperation, coupled with a binding convention. The substantive provisions of the OECD Convention require parties to criminalize the bribery of foreign public officials and to impose penalties comparable to those applicable to bribery of a party's own public officials. However, the enforcement obligations in the convention are vague and provide that investigation and prosecution of the bribery of a foreign public official shall be subject to the applicable rules and principles of each party, but shall not be influenced by considerations of national economic interest, potential effect of relations with another state, or the identity of the persons involved. But the provision I want to emphasize here is that of transparency under Article 12, which provides for monitoring and following up by a working group that was established under the convention. The working group subsequently developed an elaborate peer review system, resulting in periodic reports assessing various aspects of parties' compliance with the convention with respect to its enforcement efforts, and adopted through a unanimity -1 voting system, such that a country under evaluation cannot veto the findings and recommendations of its reports. Regular meetings in which parties discuss recent or ongoing cases and initiatives have helped in harmonizing interpretation of legislation and coordinating parallel proceedings. And this kind of informal cooperation has achieved several positive outcomes. Countries have been motivated to improve their anti-bribery enforcement efforts, and countries have been able to channel their interests in regulating one another's enforcement activities to deter under-enforcement or discriminatory enforcement. So that brings me to the conclusion. So you've seen amazing numbers of ways of cooperation, from the most traditional now to the most modern. And so I hope it helps you to appreciate how different methods of cooperation and communication have both contributed and involved in private international law. And of course, no one model of cooperation fits the diverse areas covered in private international law. For some types of issues, a focus on the unification of formal rules through treaties and regulations has been the most effective. For others, reliance on administrative and judicial assistance through central authority mechanisms work better. More recently, communication and coordination of proceedings among states, including direct judicial communication between courts, has gained importance. And still other new models incorporating working groups designed to exchange views, educate, and even to exert pressure, they have emerged. And so it's no wonder that cooperation and communication have come to be viewed as its own dimension of private international law, and that was the reason for this lecture. I thank you very much for your attention.